Hi, everyone. Thanks for being here today. Since we are such a small group, we'll keep this really informal and conversational. I'm hoping maybe a couple of others join in a minute. One quick note, we are recording the session and we may share it afterward for folks who couldn't make it, but please don't feel pressured by that. Forget that the camera is on and recording. Just a small thank you up front. This session is something Pat and we put together specifically for those of you who signed up early on our CuroNow waitlist. You've been cheering us on from the start, and these smaller gatherings are our way of giving something back while we're building the platform with all of you in mind. And hopefully we'll all learn something of value today. All right, let's dive in. I'm really happy to introduce Amy Devine. Amy is an elder law attorney with a social work background, which makes her especially good at explaining things in a way that feels human and not overwhelming. She's from Wisconsin originally, went to law school in New York. She's raising 2 daughters, and her own experience supporting her dad is a big part of what guides her work. Today, she's going to walk us through many of the things we end up dealing with, like who can make decisions if someone cannot, what documents actually matter, the difference between a will and a trust, what probate really is, and how to start thinking about long-term care planning. Amy, thank you so much for being here. I'll hand it over to you now.
Great. Thank you so much. Thank you for having me. Welcome, everyone. I'm Amy, an elder law attorney here in Monona, Wisconsin. I understand that we have people who are not in Wisconsin, which is great. You're probably warmer than we are right now. But this, as an attorney, I'm actually licensed still in New York and Wisconsin, but I really practice in Wisconsin. So what I'm talking about mostly applies in Wisconsin, but we'll be talking about kind of general concepts, ideas, things that hopefully you can take back to your own state, wherever you might be, things to think about, and hopefully can find resources that help guide you for the specifics of your state. So with that, as Rukmini mentioned, this is me and my dad, and so he was diagnosed with glioblastoma back in 2012, died in 2013. And so me, my mom, and my 2 adult brothers, we spent 1.5 years figuring out what to do. And I think back to that time period, I don't think we even knew what questions to ask. And you can't dwell in the past and things that maybe we would have done differently. But I think about that experience, and it really does guide a lot of what I do and work with families today, and understanding that everyone is really trying to do their best and understand what to do in sometimes extreme crisis mode, right? So this is me in my law school graduation many moons ago. So I'm a partner with Haskins Main Devine. And this is our focus. This is what we do. We do estate planning, elder law work around the state of Wisconsin. So as was mentioned, the idea today here is to hopefully understand a little bit more about what does it mean to make decisions, what is a decision maker, how do we even get a plan in place, right? What documents do we need? Who do we need to name? What is an estate plan? How can you afford long-term care? And then finally, kind of building a team and why an attorney can be a helpful member of that team. So elder law. So I don't work just with old people. That's a common misconception. I work with people of all ages, but really we focus on a lot of things beyond just kind of general estate planning, which is a big part of what I do. I do wills, trusts, powers of attorney, but I also do guardianship work. We do a lot of Medicaid work, so long-term care programs for people who are living in facilities or at home getting care. And then we do a lot of work after somebody passes away, after they die. So what is probate, trust administration, estate recovery if you've been on a Medicaid benefit. So we handle all of that. And I just met with a family yesterday where I've kind of started with them from the beginning. Now their mom has died, and now we're kind of trying to finish up what we started, back in the beginning when we set up all these documents. And so we really try to be with people from the beginning to the end. So I kind of separate this into 2 separate sections, is planning for life and then planning for death and the beyond, right? So planning for life really means what happens if I'm in a situation where I or someone I love, I know, can't make decisions for themselves. How am I going to move through life, make decisions about my finances, healthcare, if I'm not able to? How do we plan for what happens if my spouse, partner, significant other dies first? Or if you're caregiving for someone, if the healthy parent dies first, right? The person that is now one of the primary caregivers, what happens if they pass away first? What if someone can't remain safely in their home? How do we keep them in their home? How do we even look for a facility, navigate that whole process? And really importantly, how do we pay for it? And then finally, in all of these documents, all of the planning, we are looking outside of ourselves. We're asking other people to step in and help us, whether it's as a power of attorney, as a trustee, maybe as an executor, but we're looking for other people to help us. And what happens if we don't have a large pool of people to kind of ask to step in for these services? Or if we do, but we're just not sure if they're up for the task, how do we start those conversations? How do we find people if we don't have family and friends to rely on? So these are all conversations I have with clients every day and things that we'll talk about as we go through our time together. So again, I practice in Wisconsin. So a lot of what I'm telling you is how this works in Wisconsin. Every state is a little bit different. As I'm sure you know, there are some states that are more wildly different than others, but I know what happens in Wisconsin. So one is we are actually not what is called a next of kin state. So we are surrounded by them, but we are not one of them. What does that mean? That means that if something were to happen to me, I'm in an accident, I'm sitting in a hospital bed, and I cannot make decisions for myself, I can't pay my own bills, there is not an automatic person, even though I am married, who can just step in and take care of that for me. So that's why we engage in this work. We do powers of attorney. We do other types of planning to make sure that someone can make those decisions for us. We are a marital property state, and we are one of 11. And I think it's about 40% of the country actually lives in a marital property state, because some of our most populous states like New York and California also are, California and the East Coast and some of the West Coast are also marital property states. So sometimes we think, oh, marital property state, what's mine is yours, yours is mine. I don't really need to worry about what happens after I'm gone. Not necessarily true. It's always good to still have a plan in place, have these powers of attorney in place, and also try to set up your final documents, whether it's a will or a trust. I will also add that sometimes the time has passed for us to really meaningfully engage in this process. So it does not happen very often, but it does happen where someone is made an appointment with me or another attorney here. We sit down, we start talking, and as the meeting goes on, I realize the person in front of me really does not have the capacity to discuss kind of what their wishes are, and most importantly, to sign any important legal documents. Once we're at that point, we're exploring other avenues. In Wisconsin, we're looking most likely at guardianship if we're trying to get someone in place now to make a decision. But there is a point for some people where we can't complete that estate planning process, even though we really want to, because we just don't have the capacity to do it. There's also kind of a misconception. We'll get calls of, I want to get power of attorney over my mom, right? Or over my dad. It doesn't work that way. Mom or dad actually has to sign the document that gives me that authority to be the power of attorney, which we're going to talk about in just a second. I see every day how hard planning is. It's hard to face our own mortality. We're not always the best at it in this country. And talking about, death, dying, illness, incapacity. However, if we can meet, if we can make a plan, we can put a plan in place, usually that means we have more options. And options are always, always good, right? And building that team to kind of give you as many options as possible. And then finally, you're going to have a different plan than your neighbor. I've seen in this past year alone, the explosion of AI, right? And people turning to AI to write their legal documents. I would not suggest that for a few reasons. And that's not a self-serving answer. I will just say that AI really doesn't know you. They don't know your desires, they don't know your family, they don't know everything that you have, all of your assets. So it's really not a great place to generate legal documents. I do get asked by people if I would review an AI generated document, and I usually tell them, and this is true, it probably costs you more money for me to review an AI document than it does for me just to go about my normal plan and my kind of regular estate plan drafting. So I'll just say that yes, AI has a purpose, the internet has a purpose, but really when it comes down to making an estate plan, making these decisions, having an attorney or some other human being who knows what they're doing really is beneficial. Okay, so powers of attorney, what are they? In Wisconsin, these are two separate documents. I would imagine in most states, they are two separate documents. Each has their own requirement about how you're going to sign them, execute them. They are generally what we call durable, meaning that even when someone says, I lack capacity to make my own decisions, I am now incapacitated, that power of attorney still carries on. It still exists. It continues after that finding of incapacity, which is what you want, right? You want someone to be able to make decisions for you if you are incapacitated. So we create them now. In it, the really important piece is we are naming somebody else to make decisions for us. And I'll go through different nuances for healthcare and then for finances. We usually want to name at least one person, if not more. I like to name backup agents, right? Especially for my clients where they might want to name a brother or a sister, people in their same generation. We always want to have someone who hopefully is in the next generation who might also be able to step into that role if needed. And then they can be drafted in two different ways. So one can be what we call springing, meaning that the document is signed, it's a totally valid document. However, nobody has any power until some finding, right? Usually it's a doctor saying, okay, you now lack capacity, you cannot make your own decisions. So that's one way they can be drafted. The other way is effective immediately, meaning I sign it and then automatically someone else has that power the moment that I sign it. Pros and cons to different approaches, and they're different for either healthcare or for finances. So healthcare power of attorney in the state of Wisconsin, just some basics. We need to have two disinterested witnesses watch us sign it. That means it cannot be someone who is related to us by blood, marriage, or adoption. And I do see that people come in with, their son-in-law was their witness, right? We don't want to do that. And it cannot be part of your medical team unless it's someone, a social worker or a chaplain within your hospital. So some states want them to be notarized. In our office, we actually do both. We do witnessing and notarization just in case you're going across state lines and someone's looking for that notary stamp. The person who's signing the document is the principal, and then the people who are going to have the power to make decisions, they're called the agents. And that is who I, as the principal, am delegating power to. Now, in Wisconsin, I need to have two doctors, and we've actually updated this now. So it's a doctor and either a psychologist, advanced practice clinician, like a nurse practitioner or a physician's assistant. Two people need to examine me and say, yep, she lacks capacity to make her own medical decisions. And now we're going to activate the power of attorney. Once it's activated, that agent can now make decisions for me. It's very clear that these are healthcare decisions. And so there are some arguments among family, right? Who can visit mom in the hospital? When can they visit? I don't want mom to eat that food, right? All of those kinds of things, unless it's related to actual health care, whereas maybe your doctor is saying, right, you need to be on a low sodium diet and one kid keeps bringing in potato chips, right? That might be a place where an agent can make a decision, but otherwise it's limited just to healthcare. They're not the overlord, right? They don't have power over everything that happens. So you want to pick someone who is fair and someone who can make tough decisions, right? Because it could be something as serious as end-of-life decisions, right? Stopping treatment. Could be, in Wisconsin, placement in a facility like a nursing home or an assisted living facility. So you want to pick someone who is fair, communicates well with others, and someone who also is going to follow exactly what you want, right? So if one of your kids is they've already said that they're going to go into a nursing home the moment you're sick, and that's not what you want, that's probably not the person you want to pick as your healthcare agent. You want to pick someone who's going to honor your wishes and your values. So that's the healthcare power of attorney. For the financial power of attorney, it's a little bit different. Financial power of attorney, if you use the form that is provided by the Department of Health Services here in Wisconsin, and you can find that for both the financial and the healthcare, it is actually drafted so it's effective immediately, which means I sign it, whoever my agent is, they can immediately go to the bank and they could get added on as my financial power of attorney. It does not mean that I am losing any rights or abilities to make those decisions. So it's kind of a key difference between healthcare. I can still manage everything on my own just as long as I'm able. I'm not losing anything. The rub comes if there is a reason why I should be losing access to things. And I see that sometimes with clients where there might be kind of increasing dementia, and now that person is falling prey to scams, giving money away, paying bills 3-4 times, right? And now we're at a point where we might be in danger financially. At that point, then we're actually looking at doing a guardianship and taking away that person's ability to manage their finances. But that doesn't happen automatically. So the financial power of attorney can be effective immediately. You can also draft it so it's springing, meaning that I sign it, but nobody has any power until a doctor says I lack capacity or some other factor that I write in that says, okay, now my agent can take over and my agent can have some authority. Again, same definitions, principal signing the power of attorney, agent's the person who's making the decisions. This is a really powerful document. So sometimes we think of it just as, managing a bank account, but really it means someone who could potentially sell your house, someone who could sign you up for different government programs, someone who could work on your taxes, Social Security, right? All those kinds of things. So it's someone who could really have a lot of power over any type of asset you have, anything that's worth any money, they might be able to access and have some control over. So again, picking someone who is organized, someone who is trustworthy, someone who is good at record keeping, right? Because really they have a responsibility. They're a fiduciary. So that means that they should be keeping track of how they're spending money, keeping those receipts, right? Invoices, all those kinds of things. You also want to pick somebody who is going to not be as tempted, right, to help themselves to your account if they need it. Sadly, for any of you who kind of work in this area, that oftentimes it is someone that we know who is engaging in financial abuse, right? We have lots of outside scammers and issues, but oftentimes it is someone that we know who might also be kind of dipping into or helping themselves. So picking someone who's organized and trustworthy is key there too. So those are the power of attorney documents. That's what we need during our lifetime. Again, the key part for both of them really is who are we naming to kind of take on these really important roles. So they might be our adult children, they might be family, friends, neighbors. We might be looking to other professionals. This is an area where there certainly are some professionals that have taken on these roles. So there might be, in medicine, we have an organization that will serve as a healthcare power of attorney for people. Finding someone else to serve as a financial power of attorney, like a bank, is actually really, really difficult. At least in this area, a lot of banks are just not offering that service anymore. And so we're looking to potentially, a trust company or kind of individuals who have set up kind of their own practice to do this kind of work. But it's really challenging if you don't have someone already kind of in the queue and thinking you can do this. I always encourage clients, go out and talk to anyone and everyone before you actually name them, right? It's a big role. I've had some clients where they say, well, they're just going to find out when it's time. And that's one way to approach it. I like to be kind of upfront and have those conversations and make sure that people know that, yes, I'm calling upon you to take on this work. A power of attorney ends at somebody's death. So I die, whoever is my power of attorney, they actually have no more authority to really do much of anything for me. That's when we're kind of looking at the next set of documents, either a will or a trust, to figure out who can take action on my behalf. I do get questions too about when naming somebody, should I name the same person as my financial power of attorney, as my healthcare power of attorney? Should I name different people? That's really up to you. You don't have to name the same people. In some cases, it's great to name the same person, because that way everybody knows, who the person kind of in charge is, and they're super responsible kind of keeping track of everything. Sometimes there is only one person. In other circumstances, it makes sense, right? One of my daughters is really good at finances. My other daughter, and she also, runs out of a hospital screaming if she sees blood. And then my other daughter, works as a nurse. Well, in that case, I might pick two different people to be my powers of attorney. It's how, what are their strengths, and then do they work well together, right? If they're not on speaking terms, again, might not want to have them be two different powers of attorney where they might actually have to work together for my care at some point, right? Because my healthcare power of attorney might be making decisions about a facility, but my financial power of attorney might be the one writing the checks. So we need to make sure everyone is speaking to each other and working together. All right, and then finally, we'll talk about trust. But if you have a trust, if you've set up a trust during your lifetime, called a revocable trust or a living trust, any assets that are currently in your trust, held by your trust, those are managed by your trustee during your lifetime. It might be you might be the initial trustee, and then at your death, you'll have a successor trustee, and then they're going to manage those assets in that trust as well. All right, so that is kind of the planning for life section. There are other documents you can also fill out regarding, a burial directive. There are living wills. I work with clients on all of them, but I primarily focus on the powers of attorney, because those are really kind of the most powerful and really can be the most useful to people if they're not able to manage things for themselves. So what happens after we're gone? So many of us probably know something about wills. We that's kind of a thing that most of us know about, right? In our will, we name our beneficiaries, who's going to inherit when we're gone. We can disinherit somebody if we really want to. We can say, these are the people who are going to get my personal property, like my tangible goods, my wedding ring, jewelry, those kinds of things. And then how is everything else going to get split up? Is it my 3 kids equally, just one of my kids? I'm going to name an executor. In Wisconsin, we call them a personal representative. And we sign it the way we need to sign it, generally speaking, to disinterested witnesses. That in and of itself does not avoid the probate process, which is a court process we use to get money basically from one generation to the next. And I'm going to talk about what probate means in Wisconsin. Every state is different. There are probably some states where you want to avoid probate at all costs. In Wisconsin, it's not the worst thing in the world, but it is a process. It does require some work. So that's kind of using a will. And then the other kind of estate plan we can have is trust-based. There are many different kinds of trusts. They are not just for incredibly rich people. I think that's sometimes a misconception. They really are for a lot of people where we have property in more than one state, or maybe we have 10 people that we want to leave money to, and it might be impossible to avoid probate and give money to all those people without using a trust. I'll kind of delve into this a little bit more. But essentially, when you have a trust, it becomes the driver of your estate plan. So your trust is going to say, these are my beneficiaries, right? These are the people that I want to inherit certain things. Again, you're the person creating the trust. You're probably also the initial trustee, the person managing it. And then at your death, you're going to name a successor trustee, someone who's going to really kind of serve again as your executor, right? The person who's going to manage things for you after you're gone. For anything that's in a trust, it does not go through probate. We do a trust administration. Typically, it's outside of court, at least here in Wisconsin. So anytime I'm sitting down with somebody, we're talking about estate planning, I want to make sure I understand what their goals are. So for some people, they had a terrible experience with probate and they want to avoid it at all costs. So that's going to be our primary goal. Other people just want the most simplest, most basic plan now. And then when they're gone, it won't be theirs to deal with. I do have clients say that. So you can be kind of anywhere along that spectrum about how you want this process to go, how complex you want it to be. do you want to set up a trust for other people, right? Do you want to have some control over the people who are inheriting money, how they spend their money, right? Then we might need a trust for that as well. So depending on your goals, we sit down, right, and think about, okay, what kind of plan do we need? As I mentioned, for many people, they want to avoid probate. So we're thinking about that as part of our planning process. For some people, we want to include charitable gifts. And so if we're doing that, we're thinking about, okay, do we have a retirement account that we want to go to charity, maybe minimize some taxes, different ways we can think about that charitable giving. I mentioned kind of special planning. So perhaps I have a child with a disability and perhaps they're on public benefits that if they were to inherit money from me, they would get kicked off of those benefits because those benefits are asset or means tested. Well, I might want to set up a special needs trust for that child so that way that I don't have to disinherit them and they can still inherit money and also keep their benefits. We used to use trusts for more tax planning, and my kind of average clientele, I'm not dealing with multi-millionaires. The current estate tax at the federal level is $15 million per person. So if you're a married couple, it's $30 million. So you have to have $30 million as a married couple before you really have to worry about estate tax, at least at the federal level. And here in Wisconsin, we actually don't have an inheritance tax. So for most of my clients, years ago, we would have used a trust as part of kind of tax planning and minimizing estate tax. But the reality is, unless you have, again, multi-millions, it's not really as much of a concern. And then finally, part of your goals, if you have minor children, we'll want to consider a few other things, right? So I have minor children, so I need to name a guardian that if my husband and I are not around, right, who's going to take care of them. Probably going to set up a trust for them so that, if they're 18, they're not getting all of the money at once. Maybe they get it when they're 25, they can use it for education, but I would have a little bit of control over that up until an age when I think they're more responsible, right, about how to manage that money. Okay, so again, naming people, either an executor or a trustee. These are the people who are going to manage things for you, mostly after you're gone. Again, you want them to be organized, you want them to be fair, and you want them to be able to handle stressful situations. If you have not gone through this process of estate planning, I would bet that every state has a plan for you, right? So I mentioned guardianship. So if I don't have a power of attorney, I'm incapacitated, then we're looking at guardianship. If I haven't done a will or a trust, and I don't have beneficiaries named on my accounts, or I haven't done a transfer and death deed for my house, I'm going to go through probate, and then we're going to follow the statutes that talk about what happens to my property if I die without a will. So it goes to my spouse, and then my kids, and if I don't have those, then we kind of keep going down the family tree. So I've had a few matters where we've had to hire, an air search, right, to find that long lost, second cousin twice removed who inherited from someone who didn't have a will, and we've had to kind of go down the family tree to get that money to people. So again, benefit of planning, right, is naming the people that you want to get money and when you want them to get it. So I'm not going to spend too much time on probate because not everyone here is from Wisconsin, but in Wisconsin, if you have more than $50,000 of assets where you don't have a named beneficiary, we need a probate to transfer that asset over from, person A to person B. So what commonly happens is, I've set up a retirement account, I've named my spouse and my children, maybe I've got life insurance, right? I've named beneficiaries on those, but I have a house, I didn't do a transfer on death deed, I don't have any documentation, right, that would satisfy this requirement. It's not in a trust. Those kinds of things. So I need a probate to actually get my house, which probably will be sold, and then the cash distributed according to the terms of my will. So a will is great, but I need some other kind of legal mechanism, right, to get things over from my own name over to the next generation, whether through trust or a probate or a beneficiary designation. In Wisconsin, we have a claims period. We have to file, or we have to publish in the newspaper. So we have about 3 to 4 months where anyone can file a claim against the estate, any creditors. And usually the whole process takes at least a year. sometimes longer. It really depends on kind of what's in the estate, and then how cooperative everybody is. So it can take a long time. I think the shortest one I've had is probably about 9 months, just because we have that claims period of 4 months where we can't really do a whole lot, or waiting things to come in. So just kind of a little bit of overview of probate and why some people might want to avoid it. I always throw this slide in because I do get this question a lot. Do I need a lawyer? I talked a little bit about AI, right? I think having a lawyer is good just in the sense of someone who can get to know you and understand your assets, right? So if you're trying to avoid probate, having an attorney kind of look at your assets and what you have and guiding you through that process, I think can be extremely, extremely helpful. Or if you wanted to give more money to one kid, disinherit a kid, right? Having an attorney kind of explain all those options to you can be a really positive thing. So anytime we're meeting with an attorney, or even just thinking about our plan, right? We want to think, how complex is the plan? What are my goals, right? Do I have some businesses? Do I have properties in other states? Do I have 15 different bank accounts, right? All those kinds of things can play into how and what kind of plan we develop. What is my family like? Is it really big? Is it small? Do people get along? Do I have a lot of small kids? Where does everybody live? You don't have to have people in your state, but sometimes it can be helpful. Do I understand what I'm signing? We're lawyers. We draft things that are full of legalese, right? We're going to expect that. I have people at signings who will say, I don't really understand this. I'm just trusting you. And as a lawyer, that never makes me feel all that great, because I really don't want them to sign it. I understand we're not going to know the nuances of this tax provision and that, but I really do want them to understand, how a trust works, right? How does probate work? What can your power of attorney, for healthcare, what can they do, right? What are you giving somebody power to do? So I want to make sure people actually understand what they're signing. And then finally, am I signing the document correctly? I mentioned, right, every state's a little bit different. The healthcare power of attorney is a different execution from the financial power of attorney. So making sure that we're signing things correctly, we've got all the same dates, all of that can be crucial to making sure that those documents are actually accepted. I put up some resources here of places you can look in your own state about how to find help with some of these topics. So any of your state bar, hopefully they have some community resources. Our county has a few different programs. We have a basic estate planning clinic for people who qualify based on income. We have aging and disability resource centers in every county that are great for people to call up and ask questions about benefits, get referrals for Medicaid attorneys. There are a few nonprofits or law school clinics that also will do this kind of work. There are some free online programs. So if you donate to certain organizations, you might get an email, right? Hey, it's August's Make a Will month. Name PBS in your will, and here's how you do it with this free software. Those are all fine. Again, just making sure you're understanding what you're signing and making sure that they're signed and executed properly. Law Help is a website that has different attorney referrals, other kind of resources, fact sheets, and it's a national site. In the state of Wisconsin, our Department of Health Services is also a really great resource. We have advanced directives like the power of attorney for healthcare, for finances, a lot of other really good resources to kind of get you started in this process. And then I'll just mention the legal tune-up also here in Wisconsin, not necessarily for estate planning, but kind of other legal issues, parking tickets, those kinds of things. And then there are other versions of the power of attorney out there. Honoring choices is one of them. So your state might have a version, and then there are a few other versions out there as well. So those are just some ideas of where to go. I'll also just mention that I'm part of the National Academy of Elder Law Attorneys. And I think most states have a chapter. Ours here is pretty active, but on their website, you can go in and you can actually select a state and type in your zip code and get a list of attorneys that are part of that organization. It's a self-selecting group. We've all chosen to do this. In Wisconsin, we get together twice a year. We have a lot of really great ways to share information. So just another resource for you as you're kind of looking through, how do I go about even doing this? So that wraps up my slides. If there are any questions, I'm happy to take those.
Thank you, Amy. That was very helpful and clear. Since this is a small group, feel free to jump in. And Pat is jumping in. Go for it, Pat.
That was supposed to be a clap. Sorry, that's me and my inability to use my mouth. But I do have questions. I'll just start with one, and I don't want to hog the time because I have so many questions. If someone names a power of attorney and then things change, relationships, health, trust, how easy is it to change?
So it's fairly easy to change. In Wisconsin, all the statutes will kind of tell you how you can revoke it. But for most people, if you do a new power of attorney, you are typically revoking the prior one. Or if you just, destroy the first one, and then just make sure the new one that you're executing in the proper fashion, right? So as long as you have the capacity to make a new power of attorney, it is fairly simple to make that change.
Great, thank you.
Can I ask a follow-up question on that?
Sure.
What if, so let's say I name someone, and then we are estranged at that point when they need to be. I am incapacitated by then, but they say, I can't do it right now because Rukmini and I are not on speaking terms and I don't like her anymore. What happens if they refuse at that point?
So if the person you've named refuses to act, yes. So there's always that option that whoever you've selected, they can resign, right?
Okay.
Or otherwise are unavailable. If you have named a successor agent, that person usually then steps up. Okay. I usually have the first person sign something, right? Saying, yes, I'm resigning. If there isn't a successor and now we have nobody else listed, that's when we're usually looking at guardianship. And in the guardianship statute, there's a preference of who is going to serve as that person's guardian. And it doesn't mean that is what has, that's what has to happen, but that's kind of the order of preference.
Got it. Thank you.
Mm-hmm.
Who else has a question? Kathleen, Lon, Liz, Pam?
I just wanted to say thank you. This has been really informational. This is lots of stuff great background.
Oh, good. I was worried everyone had fallen asleep.
I fell asleep on my last call, not this one.
Okay, good. I'm glad
Thank you for your honesty, Lon. Liz might have a question. Go ahead, Liz.
Oh, sorry. Yes, this was really, really helpful. Thank you so much. What if you're in a situation where you have, an elderly parent that has already put together a lot of these documents, right? And they're not, I'm sort of thinking out loud here, they're not willing to hand it. I mean, let's say for my father, for example, he's completely there, completely, with it and everything. So it's not an issue right now, but how would me or my sister kind of interject ourselves to sort of not necessarily take over that, but work with him on that. I go to appointments with my dad, but he doesn't like to share a lot of information. So I don't have any of that,
Yeah. No, this is a very, very sensitive, challenging area, right? Because you don't want to take over until you actually really do need to take over, right? You want to respect somebody's autonomy.
Right.
A common thing I say is people have the right to make bad decisions, right? So even if it's not the decision I would have made, right? They have the ability to do that. So I often frame it as, okay, there might be a point in the future, Dad, where you can't make decisions. And I don't need all of this information now, but I do at least need to know that, have you made some plans? If you have, where are those documents? If there was an accident, right, or an emergency, right, you're in the hospital, where would I find those documents so that I can help make those decisions, right? And really start kind of having very small, purposeful conversations now.
Yeah.
right? So it's not totally overwhelming if and when that ever happens where you have to really, really step in.
No, I
But it is
think-
challenging, yeah, because you're not going to be able to call the attorney's office and just get the documents.
Right.
And so you're doing the, you can do the best that you can do, right?
Yeah. Thank you. That's helpful.
Kathleen?
Hi there. I have a question in regards to financial conservatorship. If you become one, like for my spouse, would that be something his company would know about, or do you have to turn it into his HR department, like for his 401k?
Yep, that's a great question. Are you here in Wisconsin?
And I'm in Michigan.
Michigan. Okay. So I don't know the laws in Michigan, but I can tell you in Wisconsin. So I am power of attorney for my husband, right? And I need to act as power of attorney. There is no magic wand that lets everybody know that my husband has a power of attorney. I do have to provide it to every single place. Healthcare, you might get lucky, it gets scanned into your electronic health record, and every place you go has access to all the same records. But for financial, it's not the same. You'll have to go and share that information with everybody.
Okay. Thank you very much.
Yeah.
Pat?
Okay, another question. There's sometimes fear around giving someone financial power of attorney.
Mhm.
What should people look for to know they're choosing the right person?
Yeah. So one, I would say if you are feeling nervous about it at all, then I usually draft it so it's springing, and that makes people feel a little bit better. So it's, even though I tell them just by signing this, even effective immediately, it doesn't mean they can just go in and rob you blind, right? They're not supposed to do that. But springing can make people feel a little bit better, right? So now a doctor has to say, I'm incapacitated, and now that person can take over. Again, there's no magic wand. And so perhaps it's something that we just put in a drawer or a safe for a period of time, and we don't share it with the outside world until we're ready to. In terms of thinking about people who can serve as a financial power of attorney, I ask more probing questions, right? So the person you're naming, what are their finances like? Are they likely to go through a divorce? Are there going to be ways or experiences in which they might need to tap into your money, right? Do they need your money? That's kind of one framework. And then the other is just, do they honor your values, your wishes, how you're going to spend your money? Even if they don't agree with it, are they still going to do that for you? And then also just someone, again, who can keep good records and is generally financially responsible in their own lives.
Thank you.
One of the things, and Lana, I'll go to your question. One of the things I wanted to shamelessly just plug in, this is one of the reasons, back to Liz's question, Kathleen's question. In CuroNow, you can actually, in the vault section, just notate and say, I have a financial power of attorney, and it is saved here. You don't have to scan the document and put the whole thing this way. At least your children or whoever know that the document exists and where to find it if needed. If you want to share it, you can share it, you can scan it and save it there, but that option exists.
Yeah, I can't tell you how many adult children I meet with where they're in the middle of a crisis and they have no idea where to find anything. They don't know who the power of attorney is. And it's really just extremely stressful. I actually had a client where they did an entire guardianship over another person. And then a year later, we discovered he just brought in the power of attorney. And I said, oh, you actually don't need the guardianship. So I undid the guardianship for them. But it just made no, it was so much time and stress that we just didn't need to have. So I understand that we don't always want to share all this information with everybody, but at least the existence of it.
Yeah. And then Lon, let's go to your last question. We're a minute away from our time. You're on mute.
Yeah, of course. Sorry about that. I should know better at this point. So quick question. So power of attorney, it sounds like two buckets. There's like the financial power of attorney and the healthcare directive component. Mm-hmm. There's a lot of other stuff about just like kind of like life things that don't sound like they're necessarily strictly covered under power of attorney Do they
Mhm.
need to be? So for example, like I'm involved in an elder fraud case and will be testifying in court a week from Monday for somebody that I am not a power of attorney for, and I'm not a fiduciary. I'm simply an advocate. Is that the kind of thing where, like, what's the gray area look like in terms of things that aren't strictly financial or health related?
Sure. So when I'm looking at, so I review a lot of documents for other people, right? So I didn't draft them, but someone comes in with another document, right? So I'm always reading the document very carefully and seeing what power does this give anybody? Because the financial power of attorney, in some cases, it'll give your agent the ability to create a trust, right? It really can be quite expansive and not kind of the basics of, paying the bills, exchanging property, those kinds of things. So looking at what does the document say and what power does it give somebody? The way our statutes are also written is that, at least for the financial, it says, if not otherwise granted, specifically taken away, right? This person has all of these powers. So sometimes we're reading also that what the statute says about what people can do. So I think that a lot of what we do is covered in the financial power of attorney or in the healthcare power of attorney. Things like, who can I talk to? Who can I go visit? That kind of stuff, that doesn't fall into either bucket. Who do I socialize with? Who do I have a romantic relationship with? Those are things that don't fall into either bucket. But a lot of other decisions are covered either by the healthcare or by the financial. For healthcare, facilities, placement in facilities, that's one of the things that your agent can do.
Sure.
I don't know if I answered your question, but.
Oh, that's helpful. Yeah.
Okay.
I understand that. Thank you.
Yeah, I think, looking at the document itself, and then what does the law say that a financial power of attorney can do?
Thank you so much, Amy, for walking us through this. This was very helpful, clearly, and lots of questions. So you've taken something that could have been very overwhelming and made it really understandable. Thank you all for joining. It means a lot to us, especially because you've been with CuroNow since the beginning, and really, we are very appreciative of that. We'll send a quick follow-up. That last slide of Amy's, which had the resources, we'll just email that to you so you have that. And then have a great rest of your day. At some point, once we figure out how to edit this, we will send out the recording to everyone, so you'll have all the slides and everything. Thank you very, very much, everyone. Have a great rest of the day.
Thank you so much.
Thank you.
Thank you.
Bye, everybody.